Members of the committee, you've got a pitch hitter here for this bill. As we enter into this bill, we want to acknowledge that this is a sensitive bill, a very important bill. The chair will exercise very tight control. There'll be no innuendos. I expect that our discussion will be extremely high-level, professional, senatorial. Yeah, please don't get out of order. All right. Members of the committee, you have before you for your consideration Senate Bill 262. Would the clerk please read the title and history of the bill?
Senate Bill number 262, introduced by Vincent. A bill for an act entitled, an act ratifying a water rights compact entered into by the Confederated Salish and Kootenai tribes of the Flathead Reservation, the state of Montana, and the United States of America, creating a unitary administration and management ordinance to govern water rights on the Flathead Reservation, providing exemptions from certain state water laws related to department powers, judicial enforcement, and water rights permitting, amending sections, and providing an immediate effective date.
Seeing no amendments now, discussion on the bill. Seeing none, Senator Vincent, would you, Senator Keenan.
Nice try. Thank you, Mr. Chairman, members of the committee. I have a question for the sponsor, please. And I have two areas of concern that I'd like you to address. And they're not gotchas. I'd just like to get this on the record. But on January 5th, I swore an oath to uphold the Montana Constitution. And I asked this question at the informational meeting, which I appreciate you having. But Article 5 in the Montana Constitution discusses the legislature. Section 11 discusses bills. Paren 5, if I may read that, says no appropriation shall be made for religious, charitable, industrial, educational, or benevolent purposes to any private individual, private association, or private corporation not under control of the state. Do you have any concerns through this compact that I'm violating my oath?
Mr. Chairman, Senator Keenan, violating your oath for agreeing to the compact and the settlement agreement as far as the money that is in it and the applicability of or what that money will be used for, and if that is your question, the answer is no.
Mr. Chairman, Senator Vincent, specifically...
Senator Keenan, do you further yield?
Yes.
Thank you. Specifically, we are appropriating money and water to what is organized as a private corporation in Montana law, and we are losing control of this asset. Tell me I shouldn't be concerned.
Mr. Chairman, Senator Keenan, are you referring to which portion of the settlement money are you referring to? Because the money is going to be the $42 million that is for the implement of several different things that are found in the compact are going to be put into an escrow account that is managed, by the state in conjunction with the tribe. So we're not losing control of any of that. The $13 million that is in the compact that is really for restoration work for aquatic and terrestrial species on the Little Bitterroot, which is really kind of our recognition of the fact that the tribe is not going to make claims in the Painted Rocks Reservoir, which would completely decimate the entire agriculture community in that area. Those monies are going to be given to the tribe, and it will be administered, audited, and reported on by the Attorney General in Chapter 18, as I mentioned earlier. So this has been done several times for several decades, and this is our 7th water compact with tribes, and no one has ever been successful. If you're suggesting that maybe you would want to challenge the constitutionality of it, maybe, I don't know if anybody has, but I believe that the provisions in Chapter 18 allow for that oversight and ensure that the state's resources are being accounted and properly administered as they were intended to, just like they are charged to do in I can't remember exactly the code, but I can provide it for you afterwards.
Thank you, Mr. Chairman. May I continue?
Senator Vincent, another question? You yield?
Certainly.
Thank you. A question that I'll ask you, is not the CKST organized as a corporation in Montana?
Mr. Chairman, Senator Keenan, they can incorporate as a corporation to perform duties that require incorporation. They are recognized both federally and by the courts as a sovereign entity.
Thank you. Mr. Chairman, another line of questions. One question, I believe, and again, these aren't gotcha questions, these are concerns, because this is my district. On page 14, line 19, H, Flathead Lake. And this states, the tribes have the right to all naturally occurring water necessary to maintain the level of the entirety of Flathead Lake at an elevation of 2883 feet, as described in the abstract of water right attached hereto as Appendix 18. So, and I'll give you time. My concern is that right now, and 2883, members of the committee, is the low water level allowed by Federal Energy Regulatory Commission, FERC. So my concern is, for my district, for the lake, that is a big issue. Can you give me some assurance that the current levels of Flathead Lake that are seasonally adjusted for snow melt, for generation of power, and for recreation and the like, that, excuse me, that we are going to maintain some level of Flathead Lake that is close to what we have and have had for the last 20 years?
Mr. Chairman, Senator Keenan, the requirement for the 2883 is the minimum pool. It cannot go any lower. And if you look at from 1950 until 2015, it has never ever reached that level on any revision of a FERC license, or even without one, for that matter. So my answer is that that's the water that we're talking about, and it will not go lower than that level. That is the guarantee that this compact provides.
Mr. Chairman, may I continue?
Senator Keenan, continue to yield. Senator Vinson.
Thank you. Senator Vincent, Mr. Chairman, Senator Vincent, that's not my concern. My concern is, are the levels of Flathead Lake going to be maintained at some level close to what they've been maintained for recreation during the summer, July 1st to September 1st, et cetera? There are levels that are prescribed, and they are regulated by FERC through Kerr Dam. I just want to make sure that there's some assurance that that lake level will be maintained in the future. I'm not so much concerned about this compact in general in the next 5 years. I'm concerned what's going to happen 25 years from now. But specific to the lake levels that are regulated now, do we have any assurance that in the future they will be the same or not the same?
Mr. Chairman, Senator Keenan, part of my response is we're being Pete and repeat here. The lake cannot, with this compact, forever, ever get below 2883. Okay, I'm not gonna, I can't tell you what the FERC licensing authority is going to do for the Kerr Dam, but I know that there's all sorts of things that are taken into consideration, and really the water above that is what we're talking about. If you're talking, that's the Kerr Dam levels, and that's where they're regulated. All I can say is that what this bill is doing is it's establishing a minimum pool level that is the tribe, that is where the level of that lake will never go below with this compact. That's the only guarantee that I can give you. I'm not sure what the FERC Licensing Commission is going to do on anything above that, but that's not in the purview of this legislative body for certain.
Thank you very much, Senator Vincent. Mr. Chairman, may I speak to the bill?
Senator Keenan.
And I think perhaps Senator Vincent can address this in his close, but that's why I'm concerned. We have regulated water levels. It doesn't matter to me so much as what the low pool is going to be in April. I'm worried about the future, that it be 2893, which is full pool from July 1st to September 1st for recreation, and it is brought up to that level, maintained, and then lowered. But I haven't been assured that we are going to have any input or control over Flathead Lake other than low pool will not go below 2883. Thank you, Mr. Chairman.
Is there further discussion? Senator Wendy Boy.
Mr. Chairman, I'm going to speak to the Constitution. First of all, before I go to that, Mr. Chairman, I want to go to page 1 in the bill here. And on new section 1, you'll note that that is being said that the Confederated and Salish Kootenai tribes of the Flathead has gone into a treaty on line 21 there, where it says under the recitals, where it says, whereas pursuant to the Hellgate Treaty of 1855. And I bring that date because the way I understand that in 1889 is when the state has become a state in the United States. So 1855 to 1889, you can tell there's a whole bunch of years that predates this particular item, which I'm also going to recite as well, Mr. Chairman, under the Constitution, Article 1, under the Compact, that all provisions of the Enabling Act of Congress approved February 22nd, 1889, 25 Statute 676 as amended, and all Ordinance 1 appended to the Constitution of the State of Montana and approved February 22nd, 1889, including the agreement and declaration that all lands owned or held by any Indian or Indian tribes shall remain under the absolute jurisdiction and control of the Congress of the United States, continue in full force and effect until revoked by the consent of the United States and the people of Montana. And to date, Mr. Chairman, if somebody will correct me, that has not occurred. And so getting back to page 1 here, Mr. Chairman, going on lines 23, whereas the Confederated, Salish, and Kootenai tribes claim aboriginal water rights and pursuant to said treaty of 1855, reserved water rights to fulfill the purpose of the treaty and the reservation. So the documents in itself is in pursuant of the Constitution that's been in question, Mr. Chairman. So I just wanted to point that out.
Thank you, Senator. Is there further discussion? Senator Fielder.
Thank you, Mr. Chairman. A few questions for the sponsor, if he'll yield.
Senator Vincent, do you yield?
Certainly.
Mr. Chairman, Senator Vincent, just to be clear, the compact does exempt activities from Montana Environmental Policy Act, correct?
Mr. Chairman, Senator Fielder, no.
Mr. Chairman, Senator Vincent, would you please explain the resistance to the amendment that Senator Brendan brought that included following state statute?
Mr. Chairman, Senator Fielder, the portions of 402 that are exempt are the portions that any water right applicant has to go through to illustrate that the water that they are going to be pursuing is not going to affect anybody else, because what you're essentially doing is getting new water for a new purpose, right? Is that water available? And there's some things that you have to do that. What we're talking about in this case with the undeveloped water, and the only undeveloped water is the Flathead System compact water. That water is now being made available, and it has never been available before. So we don't need to prove that the water, the DNRC knows that the water was not available. In fact, the DNRC and many people in Flathead area have been trying to get the water access to the water behind Hungry Horse Reservoir since the reservoir was built. And we've been trying to get at that water. So, but as far as the triggering mechanisms for this, all of that is going to happen. There is no exemption from MEPA or MIFSA.
Mr. Chairman, a follow-up question, please.
Another question?
Perhaps I didn't state the question correctly, but I do recall reading in the bill that that wherever the compact conflicts with state law, the compact would prevail. So there's some places where this compact conflicts with current state law. Would you agree with that?
Mr. Chairman, Senator Fielder, anywhere that the implementation of this compact would conflict with state law, what we are doing is we are accepting some changes to state law as to how waters on the reservation are going to be administered. That is a change. It's actually an addition. But in the case that you're specifically mentioning, it is for the ability to get that water, large chunks of water, to areas that need the water as fast as possible for development purposes.
Thank you. Another question, please, Mr. Chairman.
Do you yield to continue to yield?
Yeah.
Of course he will. Mr. Chairman, Senator Vincent, does the compact preclude any of this water from being leased out of state?
Mr. Chairman, Senator Fielder, Article 4, capital B, sub C, III.
Mr. Chairman, so Senator Vincent, the compact does prohibit the water from being leased out of state.
Mr. Chairman, Senator Fielder, explicitly.
Thank you.
Under Article 4, capital B, sub C, III.
Thank you. Another question, Mr. Chairman.
Yes.
Care Dam was mentioned in executive action, and you had mentioned that it wasn't involved, but there is language addressing Care Dam in the compact, and I just want to be clear, and thank you for answering the questions and trying to help me understand this better. Care Dam power generation will not be subject to regulation and rate consumer price protections by the Public Service Commission because of the language in this compact, the way I read it. Is that correct?
Mr. Chairman, Senator Fielder, my answer is no. I do not believe that to be true, but I guess I would ask you to explain. I would say this, Mr. Chairman, Senator Fielder. This compact has nothing to do with the Kerr Dam or any licensing of that dam. This compact has nothing to do with any of the pool amounts that are in Flathead Lake other than the minimum, the 2883 that is set forth in here, that pool level will not drop below. But this compact does nothing to influence any regulatory oversight, or it has no bearing whatsoever on Kerr Dam.
Mr. Chairman, thank you. Mr. Chairman, another question for the Senator.
Senator
Certainly.
Fielder.
Mr. Chairman, Senator Vincent, you're a big believer in the compact now, and you weren't last session. And one of the things that you were able to do was remove some of the streams in Lincoln County from subjectation to this compact. Are those streams, and you did that under the old compact or the last compact, but my question is, are those streams still removed from the compact? And if so, why was it important to you to remove those streams from the compact?
Mr. Chairman, Senator Fielder, back early in 2012, I was actually given a call by one of our county commissioners who said that they'd gotten a call from somebody who was following the latest in the negotiations, and that there was a draft that was being considered at the time that included off-reservation areas, in particular ours, and wanted me to take a look at it. So I met with him, we took a look at it, and we were talking about, in that draft form, Libby Creek, O'Brien Creek, Tobacco River, Graves Creek, Fisher River, Pipe Creek, Libby Creek, unless I already said that, but basically all the main arteries to the municipalities that we had in the county, and in some other areas, Yak River also, and some other areas that were in your district, Senator Fielder. And so what we did is we climbed into a car. Actually, we invited them first, and some members of the Compact Commission came back, and we had a discussion. We then, I think it was a week and a half later, drove to Polson and attended one of the Reserve Water Right Compact Commission meetings, and we sat down with some of the groups at a breakfast. I'm not sure if you were there or not for that one. And we said, you know what? We don't like what the draft proposal is. Would you be interested in seeing if the tribe would consider an alternative? And they said yes. So then I went back to my district. I met with our irrigation district, and we basically looked at it completely fresh, and we looked at giving the tribe more water than they would have gotten in what was offered to them, giving them time immemorial rights, but giving it to them in an area that protects fisheries, but that does not impact any other water right holder in the county, with the Libby Dam still there. Big Creek, Sutton Creek, Boulder Creek, and another one I can't remember. There's 4, though. And with the irrigation district members and some other concerned citizens, that's what we came up with, and we offered that, and we didn't know that they were going to agree to it until December of 2012, and they did agree to it in January. Well, I believe we found out they agreed to it in January before the Reserve Water Right Compact Commission voted it out to send it to us at sometime in mid-January, I believe, was when that happened in 2013. So that was the deal as far as Lincoln County and the water. So half of the 8 off-reservation rights that are time immemorial, that are not Murphy rights. There's 14 Murphy rights, but half of the 8 are in my county. And I know there's some folks running around saying that you exempted your county. That's why you're carrying this bill, is because you made a deal for your area, and that's why you're the sponsor. And that's not true. I had that agreement back in December of 2012, or at least when we submitted it to them. They agreed to it in January of 2013 before I opposed the other compact, because I was concerned about some of the other provisions and how they were going to impact some of the irrigators that were on the reservation. And I'm really glad that we did, because that compact, if we would have ratified it, it would have collapsed under its own weight. That water use agreement would have never have worked. That irrigation project has 40% deficient watering as it is. They were locked into an agreement that would not have worked for them. And thank goodness we didn't ratify it. But as far as my portion of that, we had that worked out with other stakeholders, sitting down with the tribe and the Compact Commission members, and had that since 2012. And nothing has changed. I mean, if that's part of your question, nothing has changed in it. There's no further exemptions. If the Libby Dam comes out, there will be 436 irrigable acres that could be subject to a call without the Libby Dam. But I'll tell you what, the biological opinion for the bull trout would make that call happen whether the Libby Dam was there or not. And I'll tell you what, if we're going to take the Libby Dam out, we have more to worry about than 436 acres of irrigable land somewhere in Lincoln County. We're going to be moving towns, and we're going to be moving a lot of people.
Mr. Chairman, another question.
Senator Fielder, Senator Vincent.
Thank you, Mr. Chairman, Senator Vincent. In executive action, I raised the issue that we keep hearing that if we don't approve this compact, that the tribe is going to make 10,000 claims against the water rights of Montanans almost all over the state. And that was a subject that was brought up by both proponents and opponents, I think, throughout the time that we had the hearings on this over the last 2 years. And I mentioned in executive action the fact that in Idaho, the state of Idaho rejected entering into this kind of a compact and instead did go to adjudication. And when they went to adjudication, their state report that was issued shows that of the over 2,000 claims that the tribes made in Idaho to in-stream flows, for federal reserved in-stream flow claims, that none of them were allowed by adjudication. None of them were granted through the court. And then you raised the point that there were 200 springs or water rights that were actually granted. Am I right? I mean, am I getting this straight right now?
Mr. Chairman, Senator Fielder, I think I'll let you get all the way to the end, and then I'll start from the beginning.
Okay. Mr. Chairman, Senator Vincent, in executive action, when I brought up this chart that was issued by the state of Idaho that shows the thousands of claims that were filed in Idaho, and only 7 were adjudicated as valid claims out of those nearly 6,000, and none of them were adjudicated off reservation for any of the tribes. And when I brought that issue up, you responded by telling me I should read the settlement, that there were 200 claims awarded to the tribes. Correct?
Mr. Chairman, Senator Fielder, no. What I said was there was a 3-judge panel. Idaho does not have an adjudicative court. They don't have a water court like we do. But what they did then is they took 3 district court judges that knew pretty well what they were talking about with water rights, and they basically made the determination that there were no off-reservation claims. Okay? The tribe then appealed that to the Idaho Supreme Court, and simultaneously, I believe they were preparing to appeal or to file in federal court. And when, as my understanding, when I drove over there and talked to some of the individuals that were engaged in this discussion on both sides of the issue, the Attorney General of Idaho, when they were looking at where this was going, reading the briefs, and had determined that they were not going to fare well in that court proceeding. So they went back to the tribe and they said, you know, can we negotiate instead of litigating this all the way through? Can we do that? This is several years into it as well. And the tribe said, sure. But you better make it pretty sweet. And they did. They gave them, the settlement included 200 off-reservation in-stream flows. 200. 2 entire fisheries, tens of millions of dollars of state money, and tens of thousands of acres of federal land. That was what happened in the case of the Nez Perce. And so my comment was even if you get a court, even if an adjudicative court doesn't agree, those decisions are going to be appealed. And when you start reading and following the case law and looking at what would happen, what would likely happen, and trying to do a risk assessment of that, should we put all of our eggs in the basket of our Montana Water Court and say, I think that they're all going to be dismissed, regardless of the fact that everybody's going to have to hire an attorney until that happens and object until that happens. That's what the outcome is. So when you say that only 7 water rights were awarded, it's just not true. They settled rather than continue the litigation. And the settlement off reservation pales our settlement in comparison.
Mr. Chairman, a follow-up on this point.
Senator Fielder. Senator Vincent, you
Mr.
continue
Chairman,
to
Senator
yield.
Vincent, are you familiar with the priority date that was provided with those 200 claims that you just mentioned?
Mr. Chairman, Senator Fielder, I'm not sure that they were all the same. They were junior to a lot of other rights. In that settlement, that was one of the things that the state felt like they got in the negotiation was they didn't get as senior of a priority date. I can't tell you exactly what it is, but I can certainly get that information to you.
Thank you. Mr. Chairman, I'd like to speak to the bill.
Senator Fielder.
The answer is that those claims have a 2007 priority date, and they are junior to all other uses and some future uses. And the rights are not held by the tribe, they're held by the state of Idaho Department of Natural Resources. There's a big difference between what Idaho was able to achieve and what's being proposed in this compact, which would turn these water rights over to the federal government to hold on behalf of the tribe. My Senate district includes people who live inside the Flathead Indian Reservation and adjacent to it and surrounding it. Three of the 4 counties that I represent are opposed to this compact. The irrigation board, the commissioners elected by the irrigators in this area are opposed to this compact. I think a lot of the opposition comes from the fact that their issues have not been resolved satisfactorily. They are not convinced that this is the right deal or the best deal or even a good deal. They're not convinced that their water rights are protected. One of the problems that I have with the compact is that the state of Montana never started from a position of strength in these negotiations. The state never identified the purpose of the reservation and the amount of water necessary to fulfill that purpose. We had testimony from the U.S. Forest Service in one of our WIPIC meetings, and that testimony was handed out to us, and this is the water perimeter methodology from the U.S. Forest Service, and it says a reserved water right is a right under federal law for the amount of water necessary to fulfill the purpose of a federal reservation. The Flathead Indian Reservation is a federal reservation. The state never determined the amount necessary to fulfill the purpose of that reservation. Instead, this compact has filtered out beyond the boundaries of the reservation and into other streams. Senator Vincent was successful in removing some of the streams in Lincoln County from the reach of the compact. others of us weren't so successful. I appreciate the Senator's effort in this compact, as well as many members of this body. But here's some of the bottom line facts that still bother me very much about this. The Bureau of Mines did an independent investigation through the interim committee, and they reported back to us that 30 to 40% of the wells will be adversely impacted because of the compact's implementation. And although mitigation funds have been provided to help address those wells that will need to be drilled deeper to get water for the people that have wells, there's no guarantee, and the hydrologist couldn't guarantee that these peoples whose wells will go dry would actually produce water after this compact and the changes of it are implemented. That's a problem. Even if it's one person's well going dry, just think what it would be like for you if you didn't have water at your home. You're finished there. The Unitary Management Ordinance, or the Unitary Management Board, turns the water rights of Indian and non-Indian people over to a tribally dominated board that will administer the water rights of both Indian and non-Indian people. That concerns a lot of people about what kind of representation they will have as water right holders, especially those people who have been opposed to the compact, and we have seen evidence presented in the committee of some repercussions for those people in dealing with the tribal government who have not supported the compact. Ownership of off-reservation waters is being granted, and it's being granted to the federal government to hold in trust for the tribes. That threat of the 10,000 claims that will be filed across Montana has pitted Montanans against Montanans. We've had people from inside the reservation asking for help, wanting a fair agreement, wanting an agreement that they know is good. And then we've had the other people from the rest of the state coming in and saying, take the agreement no matter what, or else we're going to get dragged into it, and we don't want to get dragged into it. We don't care what happens to you. We've seen a number of things wrong with the way this compact has been addressed. A lot of that started back with the old one and has carried over to this one. Members, this is a permanent and binding agreement. Once it's ratified by the state and then Congress and the tribe, this legislative body cannot change it. I wish it was a compact I could support. I wish that the Compact Commission had been able to do better and start from a position of strength for the people of Montana, but they didn't. They started from a position of weakness. We had a bad compact last session, and this one's just a little bit better. In my opinion, that's not good enough for the people of Montana and our posterity. I ask you to oppose this bill. Thank you.
Further discussion with one caveat. We had one comment that veered too close to the edge of out of bounds. I won't allow that again. Senator Ripley.
Thank you, Mr. Chairman. I forget my question. No, I have a question for Senator Wendyboy, please.
Senator Wendyboy, would you yield?
Yes.
Mr. Chairman, Senator Wendyboy, you brought up the Hellgate Treaty, and I've read some of that, but not all of it. And I've heard in the halls and various places that the tribe was not granted a water right in the Hellgate Treaty, that they were given the right to hunt and fish. Can you explain that to me?
Mr. Chairman, I'm not a Hellgate Treaty or any treaty specialist. I'm reading off what's in front of me, and I'm sure that whoever drafted this probably done their own research. But what I do know is that in 1925, well, first of all, I guess we'll go back. If we want, we can go back to pre-1492. But, no.
Mr. Chairman, Senator Wendyboy, I wasn't thinking of going back that far. I was just kind of wondering if the Hellgate Treaty actually gave a water right at that point.
Mr. Chairman, Senator Ripley, I don't know if that, but I could get you the answer, though I do have some of the members here as well as some of the legal staff.
Thank you, Mr. Chairman, Mr. Wendy Boy. I'm sure there's enough lawyers in the hall this evening. I'll be able to get the answer. Thank you.
Okay, thank you, Mr. Chairman.
Further discussion, Senator Hinkle.
Mr. Chair, I'd just like to address the bill. This has been an interesting process for me, being new to the legislature and just having to learn the whole process, and then having been placed on the Judiciary Committee where a bill like this comes and is presented, and we have to vet this. I'd like the members of the body to know that I've done as much research as I can in the time given. I know that a lot of these proposals had been on the table since July. I know that the tribe didn't accept a lot of these proposals until December, and we were never given this bill until January. And as far as learning the whole process and dealing with all the other legislation and having to look into this, I've done the best research that I can in the time given. I've reviewed comments from both the proponents, the opponents. I've discredited a lot of information from both sides, finding different facts and figures. I've gone to the informational seminar. I've questioned the legal experts. I've sat in a hearing. I tried my best to find, coherent questions to present, because there is so much information to try to understand water law and all the technical, legal aspects of it. And I've had many long conversations with the sponsor, and I think the sponsor, most of my knowledge of the bill and how this all works is through him. And I can actually read through this legislation and understand it due to, what he's explained to me. So I do thank you for his willingness on that. I expressed some concerns during the hearing, and I felt that it would be right for the rest of the senators to at least understand where I stand on this and why I do still have concerns on this, why would I would be opposing this legislation. This is not an exhaustive list, and I want to remind everyone that I've put aside all the hearsay, and I questioned the legal experts, and I've kind of tried to formulate my conclusion based on that, and then through some own studies beyond that. But I'm just going to kind of state what I stated during the hearing for those of you who didn't know. So through my own questioning process of the legal experts supporting the compact, this is what I've discovered. And I want to remind everyone, there's a lot of debate on whether on-reservation water usage by landowners are legitimate water rights. And addressing the legal experts had said, we don't know. We don't know if they're actually water rights or not. But one thing through questioning that I have discovered is that the non-Indian landowners within the borders of the reservation currently use their water in accordance with those who have water rights elsewhere in the state. Currently, lawfully, only water right holders are able to lease their water to another individual. Non-Indian landowners within the reservation currently lease their water out, which seems to establish that their water usage is in fact a water right in accordance with the law. This is how they're operating right now, as if they have a water right. In my questioning of legal counsel supporting the compact, it was made clear that the water rights of non-Indian landowners and even Indian landowners on the reservation, that these rights are currently not tribal water rights. It was also established that it's not federal water rights. But after the passage of this compact, it will be firmly established that these water rights will become tribal water rights held in trust by the federal government, thus will become a federal water right. This was admitted by legal counsel and on the record. Now I want to talk about off-reservation water rights, because this is where a lot of the contention comes, and a lot of contention even just across the state. The compact establishes off-reservation water rights for the tribe. Proponents assure us that the federal government will not have rights over this off-reservation water. But this claim looks to be false. The Federal Indian Trust Responsibility Doctrine is a legal obligation in which the United States towards Indian tribes has charged itself with moral obligations of the highest responsibility. And according to the Bureau of Indian Affairs, the Federal Indian Trust Responsibility Doctrine is also a legally enforceable fiduciary obligation on the part of the United States to protect tribal treaty rights, lands, assets, and resources, as well as a duty to carry out the mandates of the federal law with respect to American Indian and Alaska Native tribes and villages. Therefore, if off-reservation water rights and co-ownership of Montana rivers are granted to the tribe, this becomes an asset and a resource of the tribe. Therefore, the federal government has a fiduciary responsibility to protect, thus giving federal jurisdiction over off-reservation waters. There are areas of the compact that make specific reference to the Bureau of Indian Affairs having jurisdiction. And by law, the federal government is the advocate and the guardian of the tribe's interests, assets, and resources. And I do not believe it's in the best interest of this state to grant federal jurisdiction over the water of Montana that belongs to Montanans and is protected by Article 9 of the Montana Constitution. Lastly, the tribe threatens that if they do not get their way with every letter of this document, that they will go after 10,000 other water rights all across the state, costing multi-millions in litigation fees. Is this all so that they can fish? Really? I asked the tribe, how many of these major rivers and streams have actually been dewatered to the point of a fish kill? I don't know of any. I work in fisheries. Are you prevented from fishing now? I bring to the body's attention that our Montana Fish, Wildlife, and Parks is responsible for maintaining our fisheries, and they do a fine job with that. Proponents use a section of the Hellgate Treaty, also known as the Stevens Treaty, and also the threat of time immemorial to seize off-reservation waters across the state. The bill only addresses the Hellgate Treaty, but I want to bring to your attention there's actually two treaties. There's another treaty called the Judith River Treaty that the tribe did sign on to, and that establishes rights of non-Indian off-reservation landowners across the territory. The language of the Hellgate Treaty grants the tribe the right to hunt, fish, and gather off-reservation in common with the citizens of the territory. To me, that says equal. Language in the same treaty solidifies the tribe agreed to cede, relinquish, and convey their territorial right and title to all non-reserved land. This is the same treaty. That's not spoken about very much. So I have some questions that these are questions that are going through my mind. I want to get down to the root of this. Even before the compact was proposed, there was, the threat of these time immemorial rights in our waters in Montana, and that the compact was basically wanted to bring the tribe together to solve this in a negotiative type process. But I want to get to the root of why these threats or these claims are even being made. So, Senators, I asked you these questions. The tribe currently legally is able to fish and hunt off-reservation. Why should the opportunity to fish translate into an actual property right in the form of a water right? Let me ask you this. If the Hellgate Treaty grants water right because it allows them to fish, does the Hellgate Treaty also grant a private property right over land because it allows them to hunt and gather? The same question for time immemorial claims. Yes, the courts in the past, some courts have held time immemorial claims, but do you really truly believe in your core that these time immemorial claims are right? In Africa, generational landowners and agricultural producers are being forced off their land because of historical time immemorial claims. This is happening around the world. Do you believe that just because the tribe, or any tribe, had historically fished in an area, they should have a water right or property right senior to our generational agricultural producers to the point of potentially shutting down Montana's farms and ranches, the backbone of Montana's economy? Is this really worth the ability to fish? And do you really believe that this is about fishing? Lastly, do you believe the court's decisions are always right? And do you understand that court decisions can be overturned and are overturned? I still believe these threats are a form of intimidation legislation. I also believe the compact or no compact that on and especially off-reservation claims are about more than just the opportunity to fish. It is ultimately about power and control. The CSKT compact at its core is nothing more than a smokescreen, in my opinion, allowing for the federal government to acquire rights to the largest freshwater system in the United States. Now, I'm sure you all have been receiving messages from the folks around the state. And the other day, I counted up what messages were for and against the compact. I had 11 messages that told me vote for this. I had 77 messages that said vote against this. Please vote against this. People pleading to vote against this. And this has been my desk every single day. If this was a fair compact, it would have much broader public support. Every other compact that has come before this legislature has been passed by 80 to 100%. Though I've spent more time on this piece of legislation than any other this session, I am far from understanding all of the over 1,000 pages of highly technical and legal documentation, and I will not vote Nancy Pelosi style and pass a permanent legislation just to find out whether it's good or bad. If you believe that fishing translates into a water right and support giving federal jurisdiction over Montana's water, then vote yes.
Senator, we're going to retract that comment on the congressman, okay? Okay.
I'm finished.
Let's move on. Okay. Senator Brendan, do you wish to speak?
Briefly, Mr. Chairman, I think too many things have happened and been said that anything I could add would just be a reiteration of it, but I do want to show you what it says in our Constitution of Montana. Section 31. No law making any irrevocable grant of special privileges, franchises, or immunities shall be passed by the legislature. I believe this Senate Bill 262 in the compact is illegal for that reason, and I'll be voting no, and I'll just quote Voltaire about free speech. To learn who rules over you, simply find out who you are not allowed to criticize. I'd vote against this.
Further discussion. Senator Tutbett.
Thank you, Mr. Chairman. I, as many of you, have spent a lot of time studying this bill, and I am both a water user and a large irrigator. I pump from the rivers, the springs, and deep wells, and so I'm implicated in a water user. So I've looked at it from that side in agriculture, and I find this to be a good compact and a fair compact that keeps my water rights intact, and agriculture in the Flathead Valley, that our water rights are perfected. So I'm very happy with that, and I don't ever think that we'll ever see a call from this, either from the off-stream water rights or this. So I think this is a good call. And then you look at it from your constituents' viewpoint. It protects their residential. It protects the town of Kalispell. It protects the town of Whitefish from call. I think so. I think the tribes have done a good job at trying to be a good neighbor. And when you look at the thing and you try, and I want to switch, so I think it's good for my constituents, it's good for agriculture, it's good for me. And when you talk of the Constitution, as the good senator from Scobie, if we had a problem, our staff would have said it. I mean, Helen Thigpins wrote an extensive legal review and looked at this and could find no legal issues either with the U.S. Constitution or the Montana Constitution. If it was there, it would have a note. It does not. This is a good compact. It's a fair compact, and I urge you to vote for it.
Is there further discussion? Senator Brown.
Will Senator Tutvet yield to a question?
Senator Tutvet, would you yield?
Yes.
He does.
Thank you, Mr. Chair. And Senator Tutvet, I wrote something down really fast. You said that the cities in the Flathead wouldn't be in that call for water. Explain that statement a little further to me, please.
If you read Mr. Chairman, Senator Brown, basically the municipal water is exempted from call under this agreement. So any municipal water, current water rights, are exempt from call.
Further question, please.
Senator Brown. Senator Tutvet, do you yield?
Yes.
Mr. Chair, and Senator Tutvet, then here's my question. If the present ones are exempt from call, what happens when the city of Columbia Falls, Kalispell, or Whitefish in our Flathead area have to drill a new well? They have to drill a deeper well. They have to add on to their well because we're growing so much. What happens then?
Mr. President or Mr. Chairman and Senator Brown, under this, they would have to apply for a water right, a new water right, just as I would if I was drilling an irrigation well. And you'd figure out if there was adequate water supplies and they could drill a well and prove that it didn't adversely impact the well, they would get a new water right. And so that would be the process, just as any other water right user, with or without the compact. It's the same under current law right now. They can't impact my irrigation wells, and my new irrigation well can't impact the residential wells.
Senator Brown.
Further question, please.
You further yield. Senator Tutvet.
Yes.
Thank you, Mr. Chair and Senator Tutvet. They could drill a new well, but would they then have to, because of this compact, would they then have to pay for that right to the tribe in order to take more water or use more water within that new drilled well?
Mr. Chairman and Senator Brown, no. I mean, if there was adequate water, which there is, we're in a plentiful water system, no, they wouldn't. If they adversely impacted and they caused someone else's well to go dry, then that would be a different set of circumstances, but there is adequate water, so no.
Thank you, Mr. Chair, and could I direct a couple questions to the sponsor of the bill, please?
Senator Vincent, would you yield to a couple of questions?
Certainly.
He yields.
Thank you, Mr. Chair. And Senator Vincent, I wrote it down quickly, but you talked, I believe when you were talking with Senator Fielder, and I wrote it down very quickly, I put in quotes, trying to get at that water, and you were referring to Hungry Horse. Tell me who was trying to get at that water, and for what reason were they or we trying to get at that water?
Mr. Chairman, Senator Brown, the state, a lot of folks that worked on the Upper Clark Fork task force, I can't remember what the acronym is, but the folks at Senator Jackson, the task force that Senator Jackson served on, they were trying to get access to the water because when that dam was built, and I can't tell you exactly when the statement was made, but there was clearly an indication that we were going to be able to, that the people in the northwest portion of the state was going to be able to benefit from that water once the dam was built. And when issues of endangered species such as the sturgeon, the bull trout, the salmon, those prohibited that access to the water, as well as these claims that were reserved, well, not claims, but the federal reserved rights that were held in trust for the tribes, and the potential for those claims to be filed in that area was another reason. So there was kind of two reasons why they weren't allowing us to get access to that water in places that we needed additional water for development. So this opportunity through this negotiation represents probably the only opportunity that we're going to be able to have to get access to that water. And as I said before, 11,000 acre feet of it right off the top, DNRC gets to administer. Off reservation for net depletion for any development purpose. The remaining 79,000 acre feet can be used for 4 other purposes: for supplementing water on the irrigation system, for aquatic needs, for domestic and commercial needs. So we're going to be able, it's a big deal to get access to that water, and that's where the statement, we've been wanting to get at it for a long time. So it's actually pretty exciting when I hear somebody say, yeah, but you're creating a water market. And I say, absolutely, and it's a great one.
Senator
Further
Brown,
question.
Would you yield again, Senator Vincent?
Certainly.
Thank you, Mr. Chair. And in Senator Vincent, I guess that's what I'm getting at, that the 90 million acre feet. Where in that reservoir, because we raised our kids on Hungry Horse Reservoir, where in that reservoir are those 90 million acre feet? Or 90,000 acre feet, 90,000 acre feet. And I asked this of one of the lobbyists up here, and she knows to whom I'm speaking. I asked her, is that the top 4 inches? Is that the bottom 4 inches? Is it the flush water? What acre feet are we talking in Hungry Horse?
Mr. Chairman, Senator Brown, it's 90,000 acre feet.
I corrected.
I can't tell you if it's 4 inches in the bottom, the middle. What I can tell you is that there has been an assessment done on the amount of water that could be used for other purposes besides satisfying the needs for other endangered species in other watersheds in other places. So I know that because one of the things that I wanted to do and that I was gunning for on the Water Policy Committee in the interim was to try to make that market even bigger. I wanted to see if we could get more than 90,000 acre feet. And that was the response that I got when we're biologically constrained to that amount of water.
Thank you,
Senator
Mr.
Brown.
Chair. I'd like to speak on the bill.
Senator Brown.
I think that is part of one of those questions that has not been answered. Yeah, we have the water, but where is it? Is it the top layer of that water where all the people in my district have to pay for the use of the top inch of that water? Is it the water flushed through the dam that is then going to be charged in all of the Columbia River system dams going down? We had a lot of talk about the Hellgate Treaty. I haven't read the treaty, I have to admit, for a couple of years, but I do remember one thing about that treaty, that it also included that there could be no alcohol on this reservation. So if we're going to take parts of the treaty out and ignore other parts of the treaty, I don't think that's the right thing to do. I mean, let's take the treaty as it says on all parts, not just some. I also wanted to say that somebody was asked, I think one of the people in the back row here, Article 3 of the 1855 Hellgate Treaty, and this is a quote from the treaty, the exclusive right of taking fish in all the streams running through or bordering said reservation is further secured to said Indians, as also the right of taking fish at all unusual and accustomed places in common with citizens of the territory and of erecting temporary buildings for curing, together with the privilege of hunting, gathering roots and berries, and pasturing their horses and cattle upon them and unclaimed land. I do not believe the right to take fish in common is a water right. I'll leave that vote to you, but I will be voting against this for the off-reservation right.
Is there further discussion? Senator Barrett.
Thank you, Mr. Chairman. Will the sponsor yield?
Senator Vincent, would you yield?
Yes. Mr. Chairman, Senator Vincent, we've heard a lot about the off-reservation rights and a lot of dispute about the legal theory underlying those rights. But can you tell us what the practical implications of us assigning those rights are? In particular, can you tell us the ways in which the exercise of those rights are limited? What kinds of call protections, what kinds of co-ownership, what kinds of what the actual quantitative significance of these inflow rights are, and how likely they are to actually have an impact on other water users.
Mr. Chairman, Senator Barrett, it's a great question. the reason that that when I guess I would start in a place where I'm hearing a lot of the folks talk about, I'm just not sure that there is an off-reservation in-stream flow right that we should even be discussing. And I was in that exact place for a long time, and that is the risk. There is no specific case law specifically answering that question. What we do is we have to take into we have to predict what we think the outcome would be. And in my case, and I'll talk about this a little more in my close, there's over a 50% chance that that's going to happen. And when you compare that happening and compare that with the reality that these claims will have prima facie standing, which means that they will be treated like every other state water-based claim, except for you cannot get them dismissed like you can other state-based claims, meaning that lack of use, non-diversion, in-stream does not qualify to get them dismissed. The only thing that's going to get them dismissed is for you to prove that that tribe was not there in 1855. And all the other side has to do is stand there with the map from the Smithsonian saying, yes, we were. Why put people who have already been through the adjudicative process back through it? Now, when I compare that, and then I look at what we've got with this off-reservation, we're talking about 8 time immemorial flows. 8. Half of them in my county, we already talked about them. A couple of them in a couple other places that they all cannot make a call on any commercial or domestic use. All right? The only time that and they're all going to not impact any existing uses except for there is in the, like I said, if the Libby Dam was gone, in the lower 20 percentile mark, there's a chance that if the Libby Dam was gone, that they could affect 436 acres. There's 28 potential folks that could get a call on an existing water right that is like at Milltown, for example. That water right is already in stream. It's never going to be anything but in stream, and they've actually taken it from a 2,000 CFS to a 1,200. But the point is that all of these off-reservation claims are very limited, and they're going to have very, very small impacts, if any, on any existing uses. Now, when you contrast that with what the alternative is, that's the policy decision at hand, and whether or not you think that you would be successful, and even if you were successful, what you would go through to get there. So, Senator Baird, if that answers your question, I could certainly go into more detail, but I'm seeing eyes glaze over just at that point.
No, I think that'll do it. Thank you.
Thank you. Further discussion, I'd like to call on Senator Hinkle.
Mr. Chair, I just arise to apologize to my Democratic colleagues or anyone else who had taken offense to that comment or reference to Nancy Pelosi. That was not my intent, to disrespect anyone. I wanted to keep my statements consistent with what I had said in the hearing and just make reference to passage of legislation without knowing what's in it, and I didn't actually even consider that it may offend all of you. So I apologize for that, and I would like to ask for your forgiveness.
Apology granted. And forgiveness granted. Correct, Senator? Okay, further discussion. Seeing none. Senator Hamlet. I got you.
Mr. Chairman, members of the body, first, Senator Hinkle, thank you for making that apology. And, I take the Water Compact very serious, and I read it last Sunday night. It took me 5.5 hours, and I wear cheaters, but you can get through it, and if anybody has questions, you read it again, because we'll have 2 votes here, I hope. But what I'm going to talk about, I'm going to look at this as from kind of a historical point rather than hysterical. The question came up about water rights and being granted and everything. And, we've got to look at our history. There was no water rights in the territory of the state of Montana till mining came in, and that's when we started getting the system of water rights. And claiming them because you needed that for mining. And the other thing I think we need to keep in mind with our Indian tribes was, they signed treaties, but what they didn't understand was manifest destiny and what that was going to do and the impact it was going to have on them as we went forward. And back in 1855, times were different, and we didn't even know what all was going to happen to our country because we're in the 150th anniversary of the final year of the Civil War. So we spent 4 years fighting a civil war before we got on with manifest destiny. But I'm a cattle rancher, and I'm a fifth-generation Montanan, and the southern part of the family came into Montana right before we were made a territory. And the ranch property we own now, we have senior water rights on, and they're from the 1865s, and the largest ones in 1873, and then the 1880s. And on one of the creeks, we hold the only irrigation rights. Now, if the compact passes, I am still the only water right on that creek, and I'm in first in time and first in line. If this compact fails, I'm then a junior to the tribe, as their rights are either 1855 or time immemorial. And this is going to be the scenario for all of my constituents, whether they believe it or not, and in the counties that I represent, which are Cascade, Judith Basin, Fergus, Petroleum, Golden Valley, Wheatland, and Marr. And this will be the same scenario north and south of the reservation and east of the reservation until you get to a line almost directly north and south of Billings. I've studied enough history to know that the Aboriginal claims of the Flathead go a lot farther than what people have been talking about in this compact. So, and also because as a rancher, we are incorporated. When I go in to, if this compact fails and I have to go in and defend our water rights, I have to hire an attorney because we're incorporated. Even though I may know a lot of the law and think I could go in and defend myself, I will not be allowed to do so. And there's going to be a lot of my constituents that are going to have that same experience. The other thing, if this compact does not pass, it's going to start to raise land ownership issues. And the reason I say that is because just ask yourself, okay, why do you claim off-reservation water rights? And if I was a Flathead Indian, I would say, because our homeland was in the Bitterroot Valley. That's where Fort Owen was first established to trade with the Flathead Indians. That's where the first Catholic Church was established in Montana, the Jesuits established, because that was the homeland of the Flatheads. And President Grant in 1871, with an executive order from the White House, said, well, we've surveyed this country now, and I think that land up north is good enough for the Flatheads, so we're going to order them off of that land and open it up for homesteading. And that's been the case in history with the tribes. And I know Senator Brendan's got a little worry about executive orders, so if you want to worry about them, you've got a very good example with what's going on with the Indians. And if we don't pass the compact, in my opinion, I think it's going to stop and discourage a lot of businesses coming to Montana because we don't have our water settled. And we won't see our water settled, adjudicated for decades because of the scope and the reach of the tribal claims and the length of litigation that's going to happen here. Meanwhile, the downstream states and the federal government will continue to make more and larger claims on our water, and which will mean this will happen while we are continuing our litigation in water court. Now, we are playing into the hands of the downstream states, in my opinion, and the federal government that wish to control more of our waters because they were growing and they have more uses, and they will say, hey, we've been getting this water, you got to keep sending it to us. So now if we pass the compact, senior water rights will remain, and every water right holder on and off the reservation will be kept whole going into the adjudication. And once we go through the adjudication, we'll find out really where we stand, and if we don't agree, we can litigate that. On the reservation, there's been 900 exempt wells drilled without DNRC approval or tribal approval. In this compact, those will be grandfathered in, and the people will get to keep their water, their wells. In addition, exempt wells will be allowed by the tribe within the reservation of 2.4 acre feet. Ironically, this will be the only place in Montana at this time that will legally allow exempt wells. The Flathead as an area will continue to prosper as development for homes and business will be allowed. So, being a student of history, and I've spent over 40 years collecting and reading rare and out-of-print books on Montana, and a lot of the history you read, it's the good, the bad, and the ugly. It's not a day on the beach. You know, people have fought and died for this country forever. We had the intertribal warfare. We had the Indian Wars. There's the Battle of the Little Bighorn depicted up there. You go to the House chambers, you've got Chief Joseph in 1877 surrendering at the Battle of the Bear's Paw. You also see the Flatheads depicted walking to St. Louis to get the book of the white man. They wanted to get the Bible and bring it back because they thought it had power. You also see them depicted greeting settlers coming into the Montana. The Flatheads, Salish, Kootenai, Pend Oreille, they never went to war with the U.S. Army or the citizens of the territory. So I think we need to keep that in mind because of that history, we all came to the table. And I know a lot of people are uncomfortable because this is a different level of an agreement. And a compact is a complicated word, but in reality, this is a treaty. It's a treaty between the United States government, the state of Montana, and the tribes of the Salish Kootenai, and it's legal to do. And we're lucky that we get to read it, and we get to hear it, we get to ask questions, and we get to vote on it, because we're all in this together. We're a democracy. I respect those that disagree. I know water rights are, for a rancher, farmer, are their lifeblood. And if they in their mind think they're threatened, they're going to fight. And I understand that. Read the compact. Reassure yourself that state-based water rights are protected here. And thank you.
Is there further discussion? Yes. Senator Wilford.
Mr. Chairman, I would like to speak in support of the bill. I represent portions of Glacier County, Pend Oreille, and Lake County, which encompasses the Blackfeet Reservation as well as the CSKT tribe. On behalf of the Montana American Indian Caucus, we are in full support of SB 262. We believe that this compact is an equitable agreement among all water users in the area, and that the negotiations were done in good faith on behalf of everybody. We believe that CSKT has been a good neighbor, and we please ask for your support in the passage of this very important bill. Thank you.
Thank you, Senator. Is there further discussion? Seeing none, President Barrett.
Thank you, Mr. Chairman. May I address the bill?
Madam President.
Since 1979, it's true, Montana has chosen to negotiate our federal reserves and our Indian reservations rather than litigate. All of the previous water compacts were met with some opposition. Most of it was mild, but it was dealt with because those compacts were changed before they came to the legislature for ratification. However, Senate Bill 262, this last water compact, is different, and it has been described in the media as contentious, controversial, murky, uncertain, undefined, most disputed, and heavily contested. Those aren't my words. That's the way this complex compact is being described in Montana today. I believe the compact became unacceptable to the Montana citizens who are forever going to live under this compact because the unified process of negotiation has been deviated from numerous times by the negotiators in this compact. The unified process of negotiating reserved water rights are made up of 4 components. They are the original language of any treaty or reservation. This one is the Hellgate Treaty of 1855, the compliance with the U.S. Constitution and the compliance with the Montana State Constitution, and compliance with Montana's fundamental water laws. I'm an appointed member of the Montana Water Rights Compact Commission, and I have worked on this compact since 2011. 7 times since that, I have voted no to certain areas of the compact during those negotiations. I did so when they deviated, in my opinion, from state law and at least one time from our Constitution. And I apologize to everyone if my vote on January 12th, yes, to pass the compact to bring to the legislature was construed by anyone as my support, because earlier that night I spoke again of my concerns with this bill. The DNRC technical team actually, one area where I was opposed and remain is the off-reservation water rights and the way our technical team has handled them and interprets them. The technical working team of DNRC, and that's who's worked on the compact since 1979, in this case they punted and they gave the job to another executive agency. They brought in Fish, Wildlife, and Parks. They went into Senator Vincent's area, Senator Fielder's area, and one agency who was not part of the compact negotiation named, designated or identified the streams and the rivers to meet the technical team's commitment and obligation pertaining to these off-reservation rights. And at that time, you heard the story today, that brought many elected officials, county commissioners, legislators to the table, and they did work for a year, and they indeed did get things made much better for themselves and their constituents. But the changes allowed by the state technical team were not based on scientific data, science, or historical use by the tribes. I think these changes were based on not in my backyard a mentality. Keep in mind, we are uncharted waters here when it comes to hunting and fishing rights off reservation becoming an actual water right. These are not exclusive rights. They are in common with the citizens of the territory. And making it a water right will set a precedence. All eyes have been on Montana for a long time for this very reason. The bill before you on the board, Senate Bill 262, is not the only thing that the legislature is being asked to accept today. In packets handed out by the bill's sponsor, you were provided with a thumb drive with the appendices and the water abstracts. The compact section 3B actually reads the abstracts overrule the compact. Have you read and understand and completely comprehend what you're voting on today. We are being asked to adopt much. One thing in particular, one appendices, Appendix 38, is the directions and the limitations to the water court for adjudicating this compact, and it is 41 pages long. In the Judiciary Committee hearing on Senate Bill 262, it was stated quite well by the chairman that the courts are not infallible. Well, I'm here to tell you that the legislators are not infallible either. In fact, the federal government has committed several transgressions against the Indians and the non-Indians on this reservation for over 105 years. The government has breached their own laws over and over. They allowed allotments to be owned by non-Indians, and they have then turned around and paid the tribes $4.4 million in 1996 for the land the tribe members gave up in the 1800s, and then another $21.6 million in 1971 for various lands held in private hands on the reservation. It is my sincere belief that passage of this bill, Senate Bill 22 today, will become the state's first transgression against those same people, the Indians and the non-Indians, against our Montana citizens. The Montana Water Rights Compact Commission did not bring the legislature a negotiated settlement. They have dropped on the 64th legislature the largest and most expensive turf war of all time. Please know what you're voting on and vote your conscience.
Is there further discussion? Senator Ankney.
Mr. Chairman, I'm not going to argue to or for the compact. Just a matter of clarification. The original land granted to the Bitterroot, Salish, the Kootenai, and the Pend Oreille ran from the Rocky Mountain Ridge on the 49th parallel to the Kootenai River. From there to the Clark Fork, to the divide between St. Regis and the Coeur d'Alene River, extended southwest to the Bitterroot River, and then on to the Snake and the Salmon. And that original mass of land, approximately 20 million acres, was ceded back to the U.S. government. You can argue about whether it was unwittingly or whatever. It was ceded back to the government, and they was put on 1.3 million acres where they currently are. But what I'm going to say is that it's not uncommon. It's in Montana that many times your mineral rights, your water rights are retained by the tribe, even on that ceded land. That's true, I know, of the ceded strip that runs from the Wyoming border to the Yellowstone River that was Crow land. In one of their many treaties as they was shrinking that reservation. Their first agency was in Bozeman. But that strip of land in there is called the ceded strip. It was ceded in the early 1900s, and they retained mineral rights and water rights on that ceded strip. So this isn't something that's uncommon by them having off-reservation rights. Thank you.
Further discussion? Seeing none. Senator Benson, do you care to close?
I would. Mr. Chair and members of the committee, and I know we're probably past the point of me convincing or persuading anybody in this discussion, but there's a few things that I wanted to hit on that was discussed and that I wasn't able to really take a part of. And I'd like to thank the senator from Colstrip for bringing up some of the points that I think are relative to some of the other points that were brought up relative to a different treaty that was brought up in the committee hearing that we had, talking about the Judith Basin treaty. And I think it's, you know, if you're a student of history like a lot of us are, and you take a look back at what was going on back then, what's really cool about what Mr. Stevens was doing, he was pretty darn smart. He was running around, he was trying to find a way to get safe passage through these areas, and trying to find a way to make an agreement for some of these lands to be settled in the near future. He had the Judith and he had the Hellgate treaties. He had them in his back pocket. And the way that he got this accomplished, as a lot of historians have put it together, is he basically got the CSKT, and Many Horses was kind of the guy who was the chief of the chiefs who was doing a lot of the negotiating, to concede to the terms, as long as they were going to be able to go around in the area that was defined in the Judith Basin. If you put those two treaties on a map and connect the dots, they fit perfectly, and there's a reason for it. Because they were the Blackfeet were beaten up on the CSKT tribes when they would go out and hunt buffalo. And they were getting the snot knocked out of them when they go through Marias Pass. And they wanted to have some protection, so they got that protection in that treaty. But on July 16th, when Hellgate was signed, it was signed on a condition that he was going to go get this other treaty signed, and he did in October. Problem is that none of the stuff went into effect for 20 years, which is a full generation removed, which is, as far as I'm concerned, why we had the Indian Wars. Back onto the bill. If you want to talk about federal jurisdiction, I'll tell you what, we could talk about federal jurisdiction till we're blue in the face and still not get anywhere, because this body isn't going to do anything about it. We can pass resolutions against the Clean Water Act if you want to talk about jurisdictions. If you talk about federal jurisdictions, they don't need this compact to get jurisdiction, guys or gals. They're doing it through the Clean Water Act. So be real careful about what you claim this compact is doing, because what it is it's giving, we own the molecules, we're giving a right to use the molecules to an entity through a negotiated settlement. We've talked about the prima facie claims. I didn't get a chance to talk about these waters are quantified. It's in the compact. Talk to me afterwards. I'll show you where the waters are quantified in this. The problem in giving you a number of what that quantification is it's very difficult to get your arms around it, because we're talking about things like adaptive management, and there's dry years, there's wet years, there's normal years. And this settlement is so complicated that they took all the fine variables that are involved in coming up with it and put those into the abstracts. And that's why the abstracts in this are such a good thing. That's why the document is so big. Talk about water rights and adjudication. Abstracts are the golden rule. That's what you want when you go into court, as abstracts. We should be thankful that this team put together the abstracts that are in this, because they clearly define the way forward and they quantify the rights. You need to learn how to read an abstract like I did to be able to understand them, but once you do, you're glad they're there, and we will be glad they're there. You can disagree with the fact that you can say, I just don't believe in time immemorial rights. Well, you know what? Whether I disagree or agree, or you agree or disagree, this has already been decided by the courts. You can disagree with the case law. You can disagree with the Ninth Circuit Court in 1987 that said that the Flathead Joint Board of Control needed to have in-stream flows on the reservation because those rights were time immemorial. The Hellgate Treaty, on the other hand, created a reservation. That's what the Judith did not do. That's what the 1855 Hellgate Treaty did do. That's why that place of use, that new place of use, is an 1855 water right. All the other water that was flowing through there before that reservation, those are the time immemorial rights. That's what the Ninth Circuit Court has already agreed to. And as far as fishing in common, or those decisions they've got no other right other than we do in common. That's not true. The U.S. Supreme Court has disagreed with that argument 6 different times, and I encourage everybody to read those court decisions. And you can disagree with them all you want. I disagree with some of them. The tribes disagree with some of them, but that doesn't change the practical application on the ground. There was one thing that was mentioned on the Ciotti decision in 1996. There are thousands of wells that are drilled in this area right now that are actually illegal wells, that this compact is going to give those individuals a water right of the date that it was drilled. It's a pretty big deal. Wish we could do that in Montana's Water Use Act. As far as wells that could be impacted, yeah, there could be some wells that could be impacted by a change of water use, but the good senator from Thompson Falls made a really good argument for a different type of a policy decision that I think if we tried to do that, we would get in really big trouble in this body. You want to try to make somebody with a water right that tries to change their water from a flood irrigation to a center pivot take care of the neighbor's well because they were exercising their water right? This compact took that into consideration. We created a fund to help the people that could have an impact by the efficiencies that will be found in the compact. That's nowhere else in the state. Nowhere else. And it's not just drill the well deeper. It's maybe you put a cistern up there, but there will be resources to help those individuals. That's something that no one else is getting. We've heard from a lot of individuals that they feel like this compact is taking their ability to pursue their claims in court. That's why this revised compact is different than the previous one. You can accept your delivery right that travels with the land that is based upon your historic consumptive use, which is what everybody else has to prove when you're in court, trying to adjudicate your right, and to somebody else who's objecting to it, you have to show what you've put your water to. What is that beneficial use? That's determined by your historic consumptive use. They get that in this compact, and they can go adjudicate their claims if they want. They can adjudicate for co-ownership, and they get the delivery right. It's the proverbial cake and eat it too. I don't know what else we could do. As far as it being a tribal right, it has to be. Because of that 1987 decision I just talked about, there's time immemorial rights that are going to be senior. And then there's reservation rights, or 1855 rights, that are going to be senior. Even if they win the co-ownership, the earliest it's going to be is 1904 when they opened up the reservation. So they could be subject to a call. That's why we need to make it a tribal water right with an 1855 date that they have with that delivery right, so nobody else can make a call for them while they're pursuing their co-ownership if they want to. Which is why I am supporting this and opposed to the alternative, which is you get to get your delivery right, you get to adjudicate your right, or we can not do any of that and we can make everybody re-adjudicate their right. 35 basins, 40 basins, we're talking $70 million just for the water court conservative estimates, over $1 billion by some is what that's going to cost water users. And you know what? If you're incorporated and you've already adjudicated your rights and you've spent $200,000 adjudicating those rights, you better go hire another attorney, because if you're incorporated, you have to. Why should we make everybody else go back through it when we're allowing them the ability to? There is a question of whether or not these off-reservation rights would be established. I acknowledge that. But it's not precedent-setting. Idaho gave it to them. We just talked about it a little bit ago. There was actually some time immemorial rights, 1855 rights, that were in that settlement. It was like 50,000 acre-feet out of the Clearwater, as I looked at my notes. But they gave them 2 entire fisheries, gave them tens of thousands of acres of land, gave them tens of millions of dollars, but 200 off-reservation, they didn't create any precedent that did anything. Washington Supreme Court ruled that even though the Yakima tribe's right was diminished, they still gave it to them. So we have some conflicting, we have one adjudicative court that said no, we got another one that said yes. I mean, we're going to go fight that out, but do we want to? Why not negotiate like they wanted us to in 1979? Before I close, before I finish my close, I have to thank everybody that has been involved in this. I have to thank particularly the Environmental Policy Office downstairs and everybody that's in it that put up with the Water Policy Interim Committee. We worked that staff like a rented mule, as Senator Keene would say. 10 technical meetings with the Bureau of Mines and Geology. Thank goodness the Bureau of Mines and Geology stepped up so that they could help us make an educated policy decision about the water model that was central to the river diversion allowances that are in this, which, by the way, now in this revised compact can be adjusted as previous to the other one. The other water compact, you were locked into 1.4 acre feet. This one, if you're not getting your historic consumptive use, they go remove a board from the head gate, and you get it. I don't know how much better we could do. Whether you're growing wheat or melons, historic consumptive use is historic consumptive use. And the water model included the non-quota water or the shoulder water and the stuff that you're hearing in emails. But the other individuals, the Reserve Water Rights Compact Commission staff, had to put up with me for a long time with a lot of good ideas about what should really be going on inside of this compact. And I've been pretty hard-nosed about it. I've been a hard charger on a lot of it. And I need to thank them for that. I need to thank each and every one of you guys for allowing me the opportunity to carry the bill and to try to provide you with a lot of information at a time when you don't need a lot of information. Thank you all for your patience. regardless of your vote today, continue to understand this, because it has a long ways to go, and it's going to be going through the House, and it's going to have a difficult time over there just as it is over here. But we all need to keep educating ourselves so we can explain to our constituents why we did what we did. And I promise I will help anybody that wants to answer, because I'm still getting some questions to some of my answers when I'm pontificating about the 3 different things that could have happened should we have, because I'm also now having to consider, what if this compact doesn't pass? What am I going to go back and tell the folks that I represent? I failed at protecting you from this train wreck. What do I tell them? And y'all need to be thinking about that too. So I really think that this is something that needs to move forward. I really think, in fact, this is something that needs to be ratified. But we're all in this together, like it or not. And I'll leave it at that. An urge a due pass. Thank you, Mr. Chairman.
Question now arises on the motion of Senator Vincent that when this committee does rise and report after having had under consideration Senate Bill 262, recommend the same due pass. As many are in favor of the motion, will signify by voting aye, and those opposed will vote no. As every member voted, does any member wish to change his or her vote? Senator Cannell. Senator Cannell. If not, the clerk will close the vote.
Mr. Chairman, 31 senators voted aye, 19 have voted no.
31 voting aye, 19 nay. Senate Bill 262 has passed second reading.